On January 13, 2014, Curtis Reeves, a 71-year-old retired Tampa police captain, fatally shot 43-year-old Chad Olson during a confrontation at a movie theater in Wesley Chapel, Florida. The incident originated as a dispute over Mr. Olson's cell phone usage during movie previews. After an exchange of verbal hostiles and Mr. Olson throwing a bag of popcorn at Mr. Reeves drew a handgun and fired a single shot. The bullet passed through the hand of Mr. Olson's wife, Nicole, before striking Chad Olson in the chest, resulting in his death. The case was heard in the 6th Judicial Circuit Court of Florida in Pasco County before Judge Susan Barthel. Following years of legal delays, including a protracted legal battle regarding immunity under Florida's Stand Your Ground law, the criminal trial commenced in February 2022. Mr. Reeves faced charges of second-degree murder and aggravated battery with a firearm. The defense maintained that the shooting was a justifiable act of self-defense, while the prosecution countered that the defendant's actions represented a criminal abuse of force and a disproportionate response to the confrontation. On February 21, 2022, the defense called Dr. Bernard Adams, a consulting forensic pathologist, to provide a scientific reconstruction of the shooting through analyses of the medical examiner's autopsies. During direct examination, Dr. Adams explained that the downward and backward trajectory of the bullet through the chest indicated that Mr. Olson was leaning forward over the seats rather than standing upright. He concluded that Miss Olson's hand was not at rest against her husband's body, as the lack of shoring and the atypical nature of the chest wound prove a physical gap existed where the bullet could tumble. Crucially, Dr. Adams noted that Mr. Olson's hand was not in a neutral position at his side. Instead, while there was an absence of gunpowder on the tips of his fingers, the presence of soot and stippling on the back of his hand proves it was raised and oriented toward the firearm at the moment of discharge. This forensic evidence allowed the defense to argue that Mr. Olson's aggressive, non-neutral posture justified Mr. Reeves' use of deadly force. After the direct examination, District Attorney Glenn Martin had the opportunity to cross-examine him.
Good afternoon.
Good afternoon.
I want to begin where Mr. Michaels left off. We talked about how the hand is positioned and what I think you referred to it as clenched. Is that the term that you used?
Well, I didn't, but you
Flexed.
can. That's fine.
Flexed? Is that the word?
I did use the word flexed at one point, yes.
Okay. And yeah, you gave an example with the fingers into the palm.
One was the fingers wrapped, the thumb wrapped around the fingers, and one was the thumb between two fingers.
Okay. Now, you can use me an example when our hands are just hanging loose. Are our hands straight out like this, or is it natural that they are curved?
I didn't understand the question.
Sure. When your hands are just naturally by your side, you're not moving at all. You see the position of my hands?
Yes.
All right. Is that just, as we're walking along, that's just the way our hands hang, right?
Right. That's a neutral position.
Okay. I was looking for the term.
Right.
So a neutral position is, that's why Lego figures look like this, I guess. They're just that, they're like this, right? They're just hanging out.
I don't know what you mean by a Lego
Well, you
figure.
said this is the neutral position, right?
When you said Lego, did you mean like the toy, the L-E-G-O?
Yeah, that one, that's the way their hands look.
Oh, okay. That's lost on me.
No, okay, all right. But the hands are in a neutral position. They're not straight out, right?
Right. That's
And they're
extended.
not flexed or clutched,
Right.
right?
Right.
They're in a neutral position, so just kind of halfway in between.
Right. Okay.
All right. Now, you would agree that when we looked at the photograph of Mr. Olson's right hand, that the hand in a neutral position would also place the fingers out of the cone of stippling that impregnated his back of his hand and his, is this the ulnar area that you called?
That's the radial side.
Radial side, right? So if the hands are in a natural position, the fingers would also be out of the cone, correct?
Well, I wouldn't quite agree with that, because in the photograph where I pointed out that the position of the lens and the position of the muscle were almost the same, you could see the proximal phalanx of the four fingers. They were in view. That was a neutral position. Things tend to assume a neutral position after death, even though there's rigor mortis. So that photograph was a neutral position, and there was no stippling on the skin.
All right, so I'm going to use my right hand here, right? And you know that the path was front to back, left to right, right?
For the wound path through the torso.
Right, and we have
Not very much left to right, pretty
Yeah.
much front to back.
okay. But as we move, then this is not going to be exposed, correct?
As you move what?
If you have, everything's dynamic, right? When you're shot, it's a stationary, almost like a picture, right? But if our position can be anywhere before we're shot, so if it's a little bit front to back, a little bit left to right, if the hand is in the neutral position, as you say, then the fingers are not going to be in a position to have the stippling, correct?
Well, the way you have your hand position, it's a neutral position for the fingers, but they would be exposed to gunpowder.
The gunpowder is from here to here, correct?
In the photograph, right.
Okay, and there's nothing on the fingers.
So
Right.
something was either shielding those fingers, or they were flexed so that the fingers were not subjected to the gunpowder.
And they could be flexed in the neutral position, could they not?
Well, that's an oxymoron. They're either flexed, extended, or they're in a neutral position. They can't be both at once.
All right, so let's talk about in a neutral position. It's also consistent with being in a neutral position, is it not?
What is?
When the person was shot and the stippling that we see, it is also consistent with the hand being in a neutral position, is it not?
The only way to make it into a neutral position is to have the hand bent so far this way that the fingers are not exposed, and then the wound path across the wrist would then be angled. So it doesn't work.
The wound path is approximately right here, correct?
Yes.
Okay. And so we have the straight line, right? So we have this that bends, right?
Yes.
All right? So if this is flexing and it's here, 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 it could be like that and still have the straight path, correct?
That wound on the wrist was actually a little bit at the base of the thumb, so if you bend the wrist, the wound path, the area where the bullet went, is going to move a little bit. So again, it doesn't work.
You remember testifying in a previous hearing?
Yes.
Right? And that time you were placed under oath
Yes.
and testified as you have here.
Yes.
Yes, is it possible to give me a line, please, on that page?
Page 1115, line 17 through 25, page 1116. Lines 1 through 5. Now, we were talking about the stippling, and we've been talking about whether or not it would be on the fingers. And the other possibility is just the cone did not go that far, correct? The cone of stippling. It just didn't spread that far, correct?
No, we know how far the cone spread because of the spread on the forearm. So
Okay.
the only way for it not to have stippling at an equal distance on the fingers is if the fingers were flexed and out of the way, or if the fingers were shielded by an intermediary object.
You remember testifying at a previous hearing?
Yes.
All right, and you were asked questions under oath,
Yes.
and you were giving your medical opinions during that particular hearing, were you not?
Yes.
And it's important, wouldn't you agree that that you provide accurate information to the jury?
Sure.
Now, before we went up to the bench, I asked you about is the lack of the stippling on the fingers, is that consistent with the cone of stippling not being that wide? And your response was that, yes, we know the cone of stippling because on the wrist. Remember that?
No, I don't. Perhaps
That's
you
what
can
you
show me
just
the
said.
transcript.
Huh?
I don't remember it, and maybe you can show me the transcript.
No, sir. That's what you just said 5 minutes ago. We know the cone is stippling because we can see it on the wrist, right? I mean on the forearm. You just said that.
Oh, yeah, that, yeah.
Okay. Now, at that hearing, I asked you, all right, it's also consistent with the muzzle being at such a distance from the wrist that the cone is so small in diameter that it just didn't cover past the knuckles, correct? His fingers could have been out and the stippling just didn't make it that far because it's so close. Answer, yes. Do you remember saying that?
No, but I don't dispute that. That's in the transcript.
All right.
Dr. Adams asserts that a forensic determination of the shooting dynamics must be based on the physical evidence of the cone of discharge and the specific position of the hands at the moment of impact. The cone of discharge refers to the expanding pattern of soot, gunpowder, and gases that erupts from the muzzle of a firearm during discharge. By measuring the density and width of this pattern on the skin, a pathologist can calculate the muzzle-to-target distance. In this case, the analysis establishes an intermediate range of 18 to 36 inches, which serves to prove the extreme proximity of the parties within the theater row, a factor in establishing imminent danger under Florida Statute 776.012. Mr. Martin alleges that Mr. Olson's hand could be in a neutral position, and the fingers still not be in the scope of the cone. But according to Dr. Adams, the absence of gunpowder on the tips of Mr. Olson's fingers suggests the hand was clenched in a fist or flexed in a way that shielded the fingertips. This physical orientation explains why the discharge pattern did not make contact with the fingers. Unlike a neutral posture, which would imply a passive or non-threatening stance, a flexed or clenched hand in this trajectory indicates a body in motion. Here, the defense argues that the narrow spread of the discharge and the aggressive orientation of the hand provide objective physical evidence of an imminent battery. This supports the defense's theory that Mr. Reeves had a reasonable belief that deadly force was necessary to prevent great bodily harm.
Mr. Michaels went through a series of questions regarding the vulnerability of certain parts of the human anatomy, including the head area and the torso area. So I'd like to go through those with you, all right?
Sure.
Okay. I'm going to use very layman terms. You can use the medical terms to put it in what I'm talking about, okay?
Sure.
All right. Now, I'm going to go through the injuries that you talked about, and I'm just going to bullet them out first, okay? And then we'll talk about them. You talked about the left and right temporal area, correct?
I did.
Where the bone is thin?
Yes.
Okay. You also talked about the orbital sockets of the eyes?
Yes.
All right. You also talked about the nasal cavity?
Yes.
And you talked about the cheeks where the muscles underneath the bone. Remember that testimony? That area right
Yes.
here? Okay. You also talked about the neck, not only the hitting in the side of the neck, and you used the skeleton to show how that can result in spinal fluid going where it's not supposed to be, right?
I did talk about spinal fluid, but I didn't talk about spinal fluid going where it's not supposed to be. I talked about blood going into where
Blood.
spinal fluid is supposed to be.
Very good. Thank you. All right. And then we talked about the jaw being broken.
Yes.
Okay. When we talked about your previous testimony regarding the stippling on the hand, we talked about what you testified to at a previous hearing and what you testified here today. Let me just ask you one or two questions about that topic, okay?
Sure.
So
And
you know
I asked
where we're going.
And I asked you to look at the transcript so I can see the context and not just the isolated quote.
Well, maybe your attorney would want to do that. I don't know. In that statement, you would agree with me, now that you've seen that statement, or that I've read it to you and you indicated yes, that the hands being in such a manner so that when the cone actually spreads, it doesn't hit the fingers. That is also consistent with no stippling on the fingers, correct?
Well, first of all, I don't understand the question the way you've constructed it. And secondly, you're referring to testimony in the transcript which you won't let me look at. So you can repeat it every time if you want, or you can let me look at it. But at this point, I don't remember the wording in it. because I can't see it.
I read it to you. It was something about the words you didn't understand.
No, but I don't have it in front of me now. I don't remember exactly what the wording of the sentence was.
Just slide that over there. Read page 115 and 116. Now just stand here for a moment.
Sure.
Well, it looks like I didn't understand the question as you asked it. It
Your
was
Honor, I
clear at
object
this
to,
point.
no, I object to the witnesses making any statement other than when I ask it.
All right. Fair
Okay.
enough. Ask a question.
I was trying to answer the question as to whether or not he.
I haven't asked a question.
At this point, I don't know if there's a question pending. Ask the question again, please.
Did you have a chance to read the statement?
I did. I'd like to have it back so I can refer to it while I answer.
Did you have a chance to read the statement?
I said I did.
All right. And do you agree that's what you said at a previous hearing? That if the cone wasn't wide enough, that would be another reason for the stippling not to be on the fingers? Was your testimony at the previous hearing?
It probably was, although
Excuse me, Judge, that calls for a yes or no. Was it your testimony at the previous hearing?
I did not review this transcript after
me, Judge.
the
All
hearing.
right, all right. Just,
So if we assume the transcript is correct, that's an
just
assumption.
let him answer. Let him answer. Go ahead.
All right.
This is totally dependent on the accuracy of the court report. This isn't like a deposition where I get the chance to review it and make an errata sheet. I had no opportunity to do that, and I had not seen this thing until very recently. So I can't vouch for the correctness of whether this is reported correctly.
Dr. Adams declined to provide a definitive conclusion regarding the facts presented by Ms. Martin, citing a lack of total context. According to Dr. Adams, a partial data set would undermine the scientific reliability of his reconstruction, specifically regarding the dimensions of the discharge cone and the resulting biological evidence on Mr. Olson's fingers. Under Florida Evidence Code 90.612, the scope of cross-examination is generally limited to the subject matter of the direct examination and matters affecting the witness's credibility. However, because Dr. Adams was testifying as an expert witness, his testimony is also governed by 90.702. This statute requires that an expert's opinion be based on sufficient facts or data. Therefore, Dr. Adams's refusal to answer was a procedural safeguard to ensure his testimony remained legally admissible and scientifically sound. Furthermore, under Florida Evidence Code 90.614, when a party attempts to impeach a witness using a prior inconsistent statement, such as a deposition, the statement must be disclosed to the witness. Mr. Martin's strategy focused on impeachment by contradiction, attempting to highlight discrepancies between Dr. Adams' live testimony, his previous deposition, and the forensic reports. Dr. Adams resisted providing a yes or no answer to the prosecution's hypothetical questions without reviewing the full context of the record. This prevented the prosecution from creating impeachment by omission, where a witness is made to look inconsistent simply because they aren't allowed to explain the nuances of their previous findings.
What's your hourly fee?
$450,
How much are you getting paid to be here today?
same thing.
$4.50 what, an hour?
Yes,
And how many hours have you been here today?
I got here at noon.
All right, so it's 4 o'clock, $1,600?
Yeah, that sounds about right.
$1,600 in your pocket today. How many hours have you spent on this case prior to coming into this courtroom?
From the very inception,
Yes, sir.
I didn't look at the invoices, so I can't tell you.
Right.
Recently, just preparing for this trial, it's probably about 3 hours.
All right. And since the inception of this trial, how much have you been paid?
I don't know because, as I just said, I haven't looked at the invoices. I can't answer the question either for time or dollars.
All right. At the previous hearing, you would agree you were there about 4 hours also?
Sounds about right.
And prior to that previous hearing, you also had an opportunity to review material and fill out your invoice for that time?
Yes,
All right. So right now, we're at least at $3,200, another, what? Are we somewhere in the ballpark of what?
I don't know. What you say sounds good.
All right. And your testimony here today is, I don't believe what the court reporter wrote, therefore, court reporter must be wrong and not you. Is that
No.
your testimony?
I didn't say that. I said I can't vouch for the accuracy. If it's accurate, then it looks like I didn't fully comprehend the question as you asked it.
All right, let's talk about
Because my
that.
opinions haven't changed, and that
All right.
photograph hasn't changed.
All right, well, let's talk about that. At the time of the previous hearing, did you have an opportunity to say, Mr. Martin, I didn't understand that, like you've done a couple times here today?
I did.
All right, and in that particular section, you've read it. Did you say, Mr. Martin, I don't understand that question? You
I didn't
didn't
get-
do that, did you?
I don't think so, but I didn't get the chance to turn the page and see what was on the next page.
Thank you, no further questions.
Mr. Martin initiated a line of questioning intended to highlight Dr. Bernard Adams' financial compensation in the case. Under Florida Evidence Code 90.6082, an attorney is permitted to explore the bias, interest, or motive of a witness to assist the jury in assessing their credibility. This procedural right is rooted in the Confrontation Clause of the Sixth Amendment to the U.S. Constitution, which ensures a defendant and the state the right to a meaningful cross-examination to expose potential pecuniary interests. By eliciting the specific dollar amount, Mr. Martin sought to frame Dr. Adams's testimony as a biased narrative, suggesting the findings were a product of a paid professional engagement rather than objective science. Despite this attempted impeachment for bias, Dr. Adams maintained that the foundational facts of his analysis remained constant. He testified that his expert opinions and the underlying photographic evidence had not changed since the inception of the case. By anchoring his testimony to the static nature of the autopsy photographs, Dr. Adams attempted to demonstrate that his conclusions were grounded in immutable physical evidence that remained independent of his financial arrangement. On February 25, 2022, Mr. Reeves was acquitted of second-degree murder and aggravated battery. This case underscores the impact of a deficient cross-examination and the paramount necessity of credibility for any witness who takes the oath. Unlike a fact witness who testifies solely to what they personally witnessed, an expert witness is allowed to present opinions. And the jury is asked not to simply take the expert's word, but to apply critical scrutiny to the groundwork of the examination upon which those opinions are based. When that groundwork and its reasoning align accurately with the facts, the expert can carry significant weight in determining the outcome of the trial. Mr. Martin's cross-examination illustrated that attempting to undermine an expert witness's credibility by cherry-picking facts and omitting sufficient context can ultimately work against the prosecution's case. Because a jury that perceives a lawyer as avoiding the facts and instead trying to manipulate the narrative to fit a desired conclusion is unlikely to place confidence in his line of questioning. Facts and evidence are the cornerstone of an attorney's trustworthiness, and when a jury fails to see that, they may begin to question whether the intent is to establish the truth or to secure a conviction by whatever means necessary. Comment below if there is a case that you would like us to cover. Thank you for watching, and don't forget to subscribe and share.